On Radio 97, it's Talking Law Time with our resident lawyer, Despina Priala of boutique law firm Priala Legal in Runaway Bay. She's with us every Thursday morning. She gets out of bed nice and early, walks the dog, and then comes in and chats to us. She brings her legal expertise and provides some general advice on the latest hot topics. She has experience that spans more than 25 years in the area of property and commercial law. She also prepares wills as part of estate planning and litigation. Morning to you, Despina.
Good morning, Wayne. Good morning, Brooke.
Good morning, Desi. Welcome back. Another week of Talking Law. And first off, congratulations. You just won a massive case involving this gentleman buying a property and a few issues with Airbnb. So can you talk us through, what happened?
Yeah, it was a big one, and there are a lot of facts to it. So this case involves a client of ours, long-standing client actually, who wanted to buy a property at Bundaberg, and the property was being used on Airbnb. So everybody knows what Airbnb is, and I think there's been a lot of headlines, particularly recently hit around Australia in different jurisdictions about the use of Airbnb because of the other headlines hitting the media that we have in a housing crisis. And there's a lot of talk about, well, the use of Airbnb is really contributed to the housing crisis, and whether it has or has not, that's a controversial issue, maybe a topic for another time. But this involved a residential property in a residential area, a dwelling, a house that was completely renovated some time ago and then was used as Airbnb premises by the owners. Okay, so the owners bought it, they weren't staying there, and they were, renting it out for a week or 2 weeks, whatever it was, short term on Airbnb. So our client went under contract in July, and he sort of knew, yes, that it was being used for that purpose. And in Queensland, remember, it is buyer beware. But then again, whilst it's buyer beware, what people need to know, and if you are an owner of property and it is being used as an Airbnb, there are seller's warranties in the REIQ contracts, and the seller warranties extend to quite a bit. And those warranties include, for example, you stating under the contract, look, I warrant, for example, that I haven't got any show cause notices, I haven't got any other communications from council regarding either a show cause notice or an enforcement notice, which is even worse than a show cause notice, about this property. Now, it's incumbent on you as an owner, if you're selling, if you have received anything like that, you are supposed to disclose it to your buyer. So whilst it's buyer beware, you also have warranties to say, yes, I warrant this isn't the case. Therefore, if it is, you're supposed to disclose it up front to your buyer in the contract.
You say supposed to, but by definition there, that means that some people don't?
Exactly. So some people just either don't know about the warranty because their lawyers don't tell them, hey, if you've got anything from council, you've got to disclose it. Or they are aware, but they just don't want to mention it, and think that maybe the buyer won't find out. But I'm here to tell you that buyers will always find out. Well, if they do the right search, which is, being done by the right lawyer.
They have the right lawyer. Mm-hmm.
Exactly. But it's saying that, look, if a property has a show cause notice, what is a show cause notice? Very briefly, council thinks there's something wrong with the property. It could be that there's maybe even a pergola that was erected without approval from council. Or here in a case with an Airbnb, you're using it as an Airbnb, but you actually haven't got approval from council to do it. And we're going to issue you with a notice to say you're non-compliant. Now, in the practical world, what does that mean? So here we were dealing with Bundaberg Shire Council. Now, every council around Australia and different states, different jurisdictions, even locally here in Queensland, they're all different when it comes to Airbnb. And that is part of the problem. So we don't have these consistent laws across Queensland and around Australia dealing with how Airbnb can be regulated. But definitely if you're using your property as Airbnb, a house, and you haven't got a permit or approval from council, you could be in trouble. And up there at Bundaberg, yes, it required, if somebody was to use a property for Airbnb, it required a material change of use application, which we then discovered was around $20,000 in application fees. Absolutely, and infrastructure charges that would actually follow through as well, whatever they were going to be, in addition to those application fees. So it's not cheap. I mean, you could do the math and say, yeah, it's worth lodging it because of the return I'm going to get. on the Airbnb. And that's all for you as a buyer, owner to work out. But the point I want to talk about today is this seller went under contract, sold the property to my client, didn't disclose, obviously very well knew there was an ongoing investigation by council. They thought, oh, well, the buyer sort of knew, yes, that we used it as Airbnb. They can do their own searches. Absolutely not. And when we did do our rate search, it came back with a notation, by the way, that was not highlighted in bold and very difficult to find in that rate search.
Yeah,
exactly. We sort of had to read a second time to see this very fine line on the second page. It simply said, this property is under investigation. Contact council. Had no idea what that meant. And then when we contacted council, they said, yes, well, we can't give you any more information. Go contact the owner, which then we did through their lawyers. And they just, disclosed the show cause.
And they disclosed it. Whoa, sneaky.
Sneaky. And this was all 5 days prior to settlement. And what was even worse is when it all unraveled in the lead up to settlement, once we got that search and once we contacted the owner and we got more information, we then went back to council. And then what we discovered is there was a whole email trail going back 12 months, where the seller knew about this, met with council, had a pre-lodgement meeting, was going to lodge a material change of use application, just didn't bother. And you could see that there was correspondence before we went unconditional and after we went unconditional. So it was almost that the seller was just waiting for our client to go unconditional and then just didn't bother to do anything with council and was just going to let it go. And if we didn't obviously do the checks and balances, our client would have purchased a property with an ongoing show cause notice, which is an actual development offence of itself. It actually runs with the land. So yes, this is a real warning to people out there.
Because, it doesn't stick with the owner of the property. It is attached to that house. So that's what's so bad about it. It's awful.
It's so bad, and it runs with it. So just because you sold, it doesn't get magically, it doesn't disappear. The show cause notice stays. And then, of course, our client would be left with a property with a show cause notice that he had to comply with, which would be expensive, time-consuming. Lodging the application, yes, would have taken several months, whilst all the time that property would have to remain vacant. Right. So all these things came to play. Now, we exercised a clear right of termination that's given under the REIQ. And this is the other reason why I want to mention it. There's lessons all around for buyers and sellers because the seller didn't disclose, but obviously knew what was going on. They should have disclosed because they had an obligation to do that. They failed to do it. The REIQ contract clearly says if the seller breaches that warranty and doesn't disclose, then the buyer has a clear right to terminate all the way up to settlement. We exercise that right. And I think foolishly what happened after that is the seller actually contested that termination of itself, which then caused complications for my client. But in the end, we won because we did have a clear right to terminate. We were very confident we would win, and we went and filed an application within 2 days, and we had a hearing date within 3. We didn't end up going to the hearing date because the other side conceded and we settled and got our deposit back. So it's always about dealing with the issue and then how to deal with a contentious dispute and when I say hitting the other party hard, you've got to know when to do that and when not to and how to do it, and that comes with experience. But the point being, our client won and got his deposit back.
Yep. So it ended well, but of course, different councils have different ways of dealing with these things and different different amounts of money that they charge for having these changes made.
Well, this is the point. So each council will regulate Airbnb as short-term accommodation differently, and this is the problem. So we don't have a statewide consistent legislation to start with. And then secondly, we've got different local laws depending on your local council. So what might be something down here that would apply on the Gold Coast could be very different to Noosa Shire, which a lot of Airbnb premises are, because it's typically a tourist destination, and Bundaberg, Bargara, Rockhampton, any other place in Queensland. And when you think about Airbnb, I don't think, just on a general note, that it's as easy as saying it has caused the housing crisis or accommodation. I don't think that's necessarily the case, because those particular places where you have Airbnb usually are very much increased in tourist destinations. So if you don't have that for the tourists, you're not going to get the tourist trade as much, which then decreases, I suppose, the economy in that particular area or tourist, destination. So there's a lot of issues at play with, the use of Airbnb. And I don't think it's right to just simply say, well, we shouldn't have Airbnb at all. I think it needs to be properly regulated. And I think there should be consistency across the board throughout Queensland with the local councils. That's very difficult to achieve, but at least some sort of basis or foundation for consistency would be good.
Mm-hmm. And if you're selling your home, full disclosure. Make sure
full disclosure, because the thing is, if the seller did disclose, the buyer would never have had the right to terminate.
And he would have sold his place, and
everyone happily ever after.
Yeah, got out of it fine.
Exactly right. Exactly right. So lessons all round here, folks.
Thank you so much, Despina. And coming up next, the ACT is officially the first jurisdiction in Australia to decriminalise illicit drugs. Unbelievable story. Despina has the details coming up on Talking Law in just a moment.
Are you confused about legal jargon? Do you need legal advice but don't know where to turn? Tune in to Talking Law with Despina Priala every Thursday morning at 8:30 on Radio 97. Despina, a leading lawyer with over 20 years of experience, will demystify the law and provide practical advice to help you navigate legal issues. Whether it's a family matter, a property dispute, or a business concern, Talking Law has got you covered. Don't miss out on this valuable resource. Tune in to Talking Law with Despina Priala every Thursday morning at 8:30 on Radio 97.